Thank you for tuning in to this episode about a trademark application. In this episode, we'll be talking about the 3 general steps that your application will go through once it has been submitted to the United States Patent and Trademark Office. Sometimes we shorten that to the PTO or the Trademark Office. Let's get started. The 3 general steps are: Step 1, the examination step by the trademark examining attorney. Step 2, the application is published for opposition in the Trademark Office's Official Gazette. It's like the classified ads for trademarks. And finally, Step 3, the finalization before the registration certificate can be issued. Let's go over each one. For Step 1, the examination step, your application has been submitted to the Trademark Office and now you wait. This current waiting period before your application is assigned to a trademark examining attorney, we also call them trademark examiners. This waiting period can be anywhere from 6 months to almost 11 months. A lot of it depends on the Trademark Office caseload and how many examiners they have. Once your application is finally assigned to a trademark examiner, that examiner is going to review your application. They're looking to see if you have completed and complied with all of the requirements to fulfill a proper trademark application. They will compare your mark in the application that you wish to register with what's already in the database. This is the Trademark Office database, their official database. And in this database, they are looking to see if there are any confusingly similar marks that are either registered or pending an application that were filed before your application. And if so, then that may be used as a basis for an initial refusal to register your mark. If there are any hiccups, such as finding a conflicting mark or potentially conflicting mark with your application, the trademark examiner will issue what's called an office action. An office action is basically a letter from the trademark office to you or to your attorney, if you have an attorney filing your application for you, that will outline the reasons and the requirements to overcome this particular initial refusal. Some requirements, they provide suggestions. Other requirements, they don't. They just say, hey, here are the issues that we found. You have a certain amount of time, typically 3 to 6 months, to submit a response to the office action to hopefully overcome that rejection. Not all applications get office actions. And if they don't get an office action, then your application moves on to Step 2. If you do have an office action, then your attorney will review that information for you and will give you an idea of the different ways that you can try to overcome that application, or if other appropriate steps are available to you. If that application that has an office action is overcome, then the mark in that application moves on to Step 2. If the application does not, if your response to the office action does not satisfy the examiner's requirements, we'll send another office action, which we call the final office action, and then your attorney will go over the different process for you at that time. Here's a tip during Step 1. Watch out for potential spam or junk mail that invites you to sign up for services if you pay this company additional fees. Junk mail should have a solicitation notice at the bottom of the letter. Not sure if you've received junk mail? Contact your attorney to double check. Remember, only your attorney or the Trademark Office, if you file on your own, will contact you about your application. Also remember, government fees are generally only due for filing fees, statement of use fees, if applicable, and extension fees, if applicable. Keep in mind that some exceptions may apply. Not sure? Contact your attorney. Let's move on to Step 2. For Step 2, published for opposition in the Trademark Office Official Gazette. This Official Gazette is like a classified ads for trademark applications. Right now, at the time of this recording, the marks in the applications are published every Tuesday. And what this does, it allows third parties or other people who may have an interest in a similar mark for similar products or services, they have an opportunity to oppose or contact you or the Trademark Office in an effort to stop registration of your mark. These third parties have 30 days to submit a notice of opposition or an extension of time to oppose this particular application. Currently at this time, the Trademark Office does not affirmatively notify anyone that your particular application has been published for opposition. Marks are published every Tuesday, like I mentioned before, and there are thousands upon thousands of marks. So unless your mark is something arguably similar to something that is being monitored, such as the big brands, or maybe someone happens to come across your brand, the chances of someone opposing your mark may be on the slimmer side, but there's no guarantees. If no one opposes within that 30 days, then your mark in the application goes on to the last step. Step 3. Step 3 is the review before final registration. In this step, your application has already been examined, no one has opposed, now you're just waiting on the formalities to get a registration. If you filed your application as what's called an actual use application, or an application that has information and evidence that you're already on the market with your particular product and services that are branded, then your mark will go ahead through the registration process and you will receive your registration certificate in a few months. If, however, you filed an intent to use application where you intend to use this particular mark for your products and services at a later date, then it is now time for you to submit that evidence. At this step, the Trademark Office will send what's called a notice of allowance. With the notice of allowance, the Trademark Office is saying, hey, we need your evidence of use, meaning for products and services, we need to see some kind of branded evidence. And then also we need your earliest dates of first use in commerce and in interstate commerce to show that you are now in business with this particular mark. So you have 6 months from the notice of allowance date to give this evidence. If you're not ready to give that evidence at this time, then you can submit one of 5 6-month extension requests. There are additional fees for this last step of the intent to use application. Once you do submit this information to the Trademark Office and the examiner reviews it, if there's no further questions, then your mark will finally get registered and you can use the R with the circle around it. Final tips. Until your registration is complete, you cannot use the R with the circle around it, that symbol that goes at the end of your mark. But what you can do is you can use a TM or an SM designation next to your mark. This lets people know that you consider this particular trademark your trademark versus just a cool phrase or a cool logo. What can you do while you wait for your trademark application? You can secure an online presence by getting URLs, social media accounts, and other online locations in the name of your company or trademark. You can develop your style guide for trademark consistency, such as creating a logo or graphic design and using specific color and font schemes. Copyright tip. Don't forget to have your graphic designer sign a copyright agreement so you own the copyrights in the artwork and are not merely getting a license. You can also use a TM or SM if you have a service mark in connection with your products and services. For intent to use applicants, you can go ahead and launch your brand or trademark and start using that trademark in connection with your products and services that are listed in the application. Don't forget to keep copies of your records for out-of-state sales and in-state sales, including the earliest dates of those sales. Don't forget to take photos of the product as well. Did you find this information helpful? Please like and subscribe. To contact me, Rashauna Norment, for speaking engagements, please visit dreamunique.com. To contact me as an attorney for legal services concerning intellectual property, which covers patents, trademarks, copyrights, and intellectual property licensing, please visit normentlawfirm.com. Thank you and have a wonderful day. Dream Unique.